How does divorce affect a grantor trust? Have you ever wondered how a divorce can impact a grantor trust? This is a topic that many people overlook, but it can have significant implications for your estate planning. Let's break it down in simple terms. First, it is essential to understand what a grantor trust is. A grantor trust is a living trust created by an individual, known as the grantor. This person retains control over the trust's assets and income during their lifetime. The grantor funds the trust, manages its assets, and decides how and when distributions are made. For tax purposes, the grantor is treated as the owner of the trust assets, meaning they report all income and deductions on their personal tax return. Now, when a divorce happens, several key issues arise regarding a grantor trust. The first point to note is that ownership and control of the trust remains with the grantor. Divorce does not automatically change who manages the trust or its assets. The grantor continues to oversee the trust and report income regardless of their marital status. Next, we need to consider how the assets in the grantor trust are treated during the divorce. Whether these assets are considered marital property depends on state law and the specific circumstances of the marriage. If the trust was funded with marital assets, or if marital funds were used to contribute to the trust, those assets might be divided during the divorce. On the other hand, if the trust assets are separate property, such as those funded before the marriage, they may be protected from division. Another important aspect is the beneficiary designations in the trust. Divorce can affect who is named as a beneficiary. Some states have laws that automatically revoke a former spouse as a beneficiary upon divorce, while others do not. If the ex-spouse remains a beneficiary, the grantor may need to amend the trust to reflect their new intentions. Since grantor trusts are often revocable during the grantor's lifetime, the grantor has the ability to amend or revoke the trust to address changes caused by divorce. This can include changing beneficiaries, trustees, or distribution provisions to align with new estate planning goals. It is also important to note that divorce does not change the tax status of a grantor trust. The grantor continues to report trust income on their personal tax return until their death or until the trust becomes irrevocable. However, if the trust is amended, or if assets are removed or transferred as part of the divorce settlement, there could be tax consequences to consider. From the perspective of elder law and estate planning, a divorce may prompt a thorough review of the grantor trust. This review should ensure that the trust reflects the grantor's current wishes and family situation. It is essential to address asset protection, control, and the disposition of trust assets to avoid unintended consequences or disputes after the divorce. In summary, while divorce does not inherently change the ownership or tax treatment of a grantor trust, it can affect the division of trust assets, beneficiary designations, and the terms of the trust. The grantor typically retains the ability to amend or revoke the trust to accommodate changes resulting from divorce. Consulting with an estate planning attorney is essential to update the trust accordingly.